So, trans history. Now, I could spend all night talking about this. And if you've read my book, Trans Britain, then you'll know that it comes in several parts. Tonight, I want to concentrate on the activism part. But I think to explain the activism, I think we have to put that into some historical context itself. As many of you probably know, you can trace trans history back as far as you care to do so. Cheryl Morgan has done some great work, literally digging up Romans. I'm figuring out actually that when we first came down from the trees, one of us at least was trans. But I think the first icon people know about was the Chevalier d'Eon, the end of the 1700s, the early 1800s. And then there are tales of the various people who worked usually as men actually, during the mid 1800s, and were only discovered to be trans men when they died and were prepared for burial. And then you get the stories of the research work that took place in Germany under Magnus Hirschfeld at the beginning of the 1900s. And when I was researching my book, I found lots of tales reported in the press of people who had clearly transitioned in the 1930s and the 1940s. One of the most famous of those was a trans man called Michael Dillon. And if you want to read up on Michael Dillon, then a very good place to start is this book, which I think might be back to front for you, but I'll read the title. It's From a Girl to a Man, How Laura Became Michael, by Liz Hodgkinson, who's written a number of books over the years about trans people. I understand that Michael's own autobiography has now been published as well. It wasn't published in his lifetime. So we've got lots of examples of people living trans lives for a long time before we were assumed to officially exist. What struck me about all of those lives was, with maybe only one or two exceptions, those people never had met another person like themselves. They were solitary. We know about them, and they succeeded in transitioning because they had the resources, usually by luck of birth, because they were independently rich, to do something about their transness. And they managed to find specialists who could help them in Wimpole Street and I nearly said Carnaby Street. That's not the right one, but you know where I mean. And it's the rest of us only got to know about trans people and perhaps about each other when we started to be featured in the newspapers. Around about the time I was born, Christine Jorgensen was splashed across the front pages of newspapers literally around the world. And then in Britain, there was also the story of Roberta Cowell, who had, prior to transition, been a World War II fighter pilot and latterly a racing driver, and then sold her story to one of the pictorial weekly newspapers, the Picture Post, for what was probably in today's terms around about £200,000. So a story like hers was greatly valued. And that's actually where the habit, I think, of the newspapers reporting us in a certain way actually took root. Certainly by about 1958, Michael Dillon, who I've already mentioned, he was working as a ship's doctor, and he became outed to the press. They pursued him to where his ship docked next in New York, and he arrived in New York to find the press on the quayside with their enormous cameras and their flashy, their flashes, wanting something from him. he was traumatized and actually gave up medicine and became the first Westerner to become a Tibetan monk. So by the beginning of the 60s, we could hear that there were people like ourselves. I remember when I was about 12 years old in 1966, I just got old enough to read the newspapers, and my father in those days used to take the News of the World and the Sunday Mirror. So that sort of gives you an idea of the sort of family that I come from. And I remember seeing the hoarding outside the newsagents when I went to collect the papers for him about somebody called April Ashley. And so as soon as I got back, my parents ran a pub, so they were preoccupied serving customers downstairs, and I spent lunchtime on my knees in front of the fire in the kitchen reading the News of the World's account of April Ashley, who was then becoming notorious because she was trying to divorce her husband, Arthur Corbett. And in that moment, through the newspapers, I learned that there were other people like me. I'd known I was different and that I wanted to be a girl from about the age of 4. I remember telling my mum at that time, and I learned very quickly that I shouldn't have told my parents because they laughed and they brushed it off. But now suddenly I've got some confirmation that there were other people like me, but also at the same time that it wasn't a good thing to be. So I carried on at school and went to university, and in 1974 there was the publication of the first autobiography by a trans person that I knew of at that time, called, oh goodness, she died a couple of weeks ago, didn't she? Jan Morris. So anyway, what I want to stress here is that, as I said, people were mostly isolated. Then in about the 1960s, unbeknown to me at the time, some people got together and formed a support group called the Beaumont Society. One of the founders, Alice Purnell, lives in Brighton. Well, she lives in Hove, actually. She's a very important figure in our history for decades. So with the Beaumont Society, there was an opportunity for people to join an organisation for people with common interests, and people formed local chapters around the country. And it was actually through one of those kinds of meetings that I first met somebody like me in a back room in Manchester in the about 1974 again, and that actually became the model then for all of us, that aside from occasionally reading about us in the newspapers, there was support. But nobody considered at the time that there was any possibility about doing anything about the dire position that we found ourselves in. What I mean by that is that when April Ashley's divorce reached the courts, her husband, in order to avoid having to pay any alimony, argued through his lawyers that their wedding, their marriage had never existed, because he argued that for the purposes of marriage, she wasn't a woman, and therefore it couldn't exist, because in those days, under the Marriage Act of 1956, the marriage could only be between a man and a woman. Interestingly, the law didn't actually define what those two categories were, but people were pretty sure what they thought they meant. So yes, we looked after each other. We met periodically. I found it was a great comfort through the 70s, when I was first thinking of transitioning, to actually have people I could talk to. Although actually in those days it could be very confusing, because it was a group that was both for people who cross-dressed and for people who were, in the terminology at the time, transsexual. And the cross-dressers hugely outnumbered us transsexuals. So evening meetings were often dominated by people drinking beer and talking about steam engines. But again, as I say, there was no conception that we could actually do anything about our position. April Ashley's case had meant that we became defined as being of our birth sex, at least for the purposes of marriage. And then later, another case came along on a different subject, where it became sort of crystallized that we were of our birth sex for all purposes. And we could do nothing about it. And who could we appeal to? We couldn't go to the newspapers because they'd actually found a way of representing us as the equivalent of clickbait in those days for their Sunday newspapers. We were the shock story, whether we liked it or not. We couldn't go to a member of parliament because there was nothing in it for a member of parliament to support a trans person. So where else would you go? So at the time, during the 70s and the early 80s, one of our number, a trans man called Mark Rees, who had transitioned in about 1972, I think, decided that he'd had enough of this and decided to take the government to court. And he, as you had to do in those days, prior to the Human Rights Act, he took it through the domestic courts, and having exhausted all the possible remedies there, he was able to take his case to the European Court of Human Rights, which took several more years, so that in 1986, 87, his case came before the judges at the European Court. And although they were incredibly sympathetic, they didn't find in his favour. But what was interesting at that time was that there were judges who disagreed and wrote their opinions that actually there should be a facility for people to legally change their gender. And what they did for us was that it showed that there was a third way. I've ruled out newspapers, I've ruled out MPs and Parliament, but it seemed that judges could hear what we had to say. They could look at the genuine evidence of the problems in our lives through being treated as our birth gender and not being able to change our birth certificates. And they thought there was some merit in that. And the reason why they didn't find in Mark's favour was because of a doctrine in the European Court, which is made up of, the European Court of Human Rights is nothing to do with the EU, by the way. It's established separately, but and it covers a wider number of European states. But what it does is it looks at what the consensus is. So at that time in the 1980s, there were a number of European countries that had legislated some form of legal recognition for trans people. Germany was an example, Sweden, and the other Nordic countries, South Africa. Those are the ones that trip off the tongue. I think there were one or two others. They weren't very good laws because they were the product of the way that people looked at us in the 1980s. But at least there was a mechanism if you were hardy enough to fight your way through it and didn't mind the insistence, for instance, in Sweden, that you be incontrovertibly sterile, but as a result of gender reassignment before you could be legally recognised. So where did that take us? Well, it showed, as I say, that there was a way that maybe we could change opinions. And there was a trans man still around these days called Stephen Whittle, who hadn't thought of studying the law, I think, up to that point. But he felt moved to think that maybe if he studied the law, and was able to make a case and get some other, some practicing lawyers on side, that we might be able to take something to the court in future that could advance our position. And that was underlined in 1989 by an almost identical case to Marx. And that was the case of Caroline Cossey, who was a television presenter and model. And she had been outed by the newspapers, ending her career as a model and also ending her engagement to be married as well. And she took to the European Court of Human Rights a case that was, as I say, almost identical to Marx, because our problems in terms of lack of privacy and lack of guarantee of the ability to marry were the same no matter who the plaintiff was. And what that led to as a result of those two cases was Stephen and his friends, I wasn't involved with them at that time, getting together at the encouragement of the Liberal Democrat Home Affairs spokesman at that time, Sir Alex Carlile, who met them in Parliament and was very sympathetic to our cause and said, well, look, you're going to have to set up some kind of group to advocate for your cause. And it's going to take a long time. He reckoned it would take about 10 years. In fact, he was almost exactly right. So they went away across the road to a tea shop that's no longer there because it should have a blue park on it. But they got together and they said, okay, we're going to set up this group. There are about half a dozen of them. What shall we call it? And they went through all sorts of different possibilities. And somebody said, because over and over again in the conversation, people were saying, we need to press for change, we need to press for change. And somebody said, well, why don't we call it Press for Change? Because we'll be doing what it says on the tin. And that's how Press for Change was formed on the 27th of February, 1992. Now, the following year, I'd been doing little bits and pieces for myself, and I got noticed and I got invited to, well, actually, we kept bumping into each other at conferences. I went to a conference in Amsterdam and Stephen was there. I went to a conference in New York and Stephen was there. And after a bit, we said, we can't keep meeting like this. We ought to formalise this arrangement. So I got invited to a planning meeting of this very young group where the whole of Press for Change could meet in somebody's lounge and sit on the seats. So I got involved, as I say, towards the end of 1993. And at that point, there was a name. Somebody was working on some objects for us to have. And one of the campaigns that we were going to have to begin with, because there was a general election in 1992, and we were going to write to all of the new MPs when they took up their seats. And in those days, very, very few people had email. Nobody had ever heard of the World Wide Web, or at least not outside of universities. And I was a computer consultant, so I'd heard of it, but I didn't have it. And in those days, if you wanted to write to MPs, because you can't just put them all in a sack and send them in one big box, we had to write these individual letters, sign them individually, and then put them in envelopes individually, address them individually, stick stamps on them individually, and post them individually. And if you're writing to, I think in those days there was about 550 MPs, the first class postage alone was quite expensive. But it was our first act, and it sort of got us off the ground. And we spent quite a long time sort of finding our feet as to where we were going next. And a case presented itself in 1993. Somebody we knew who was an education manager down in Cornwall, had just had an appraisal with their boss. And during this appraisal, they'd had lots of praise heaped on them. You're a great asset to Cornwall County Council. We really need you. We're going to give you a promotion or whatever. And then they said, well, since we're having this conversation, this is a good moment to perhaps explain to you that I intend to change gender, and I will be coming back to work as a woman. And the atmosphere completely changed in that instant. And by the end of the afternoon, this person, who we came to refer to only as P, was out on their ear with their box of personal belongings, marched to the door by security. But they weren't the sort of person to take it lying down. So they went to employment law solicitors, and they pursued a case in what was then called the Industrial Tribunal. And their solicitor argued that this tested a point of law in European law, because we'd been part of the what was then the common market since 1972. And when we joined the common market, we had the legislation that transposed European laws into British laws included giving force to something called the Equal Treatment Directive. And the argument was that this was discrimination on the grounds of sex. Which is interesting, because in 1975, when the Sex Discrimination Act was debated in Parliament, there had actually been a specific question about whether the Sex Discrimination Act would cover transsexuals. And the Bill Minister would say, oh yes, it will, it covers everybody because everybody's got a sex. But then wily lawyers had argued subsequent to that it wasn't sex discrimination, so long as they said, we have sacked this trans woman, but we would have sacked a trans man too, ergo it's not sex discrimination. So P wasn't satisfied with that. They took it to appeal, and then the appeal court referred it to the European Court of Justice, which is not the same as the European Court of Human Rights, but it's the court that legislates on whether states are complying with European law. And in 1996, the European Court of Justice came back and said, yeah, you're right, that's sex discrimination, because it's discrimination on the grounds of an aspect of your sex. You couldn't be changing sex if you didn't have a sex, and therefore it's sex discrimination. So we had our first win. So we've been set up in 1992, and in 1996, we had our first big win in court, which showed that the point of actually using the courts, using litigation, actually could advance our cause. And incidentally, having done that, we'd won rights for trans people, not just in Britain, but across the whole of the Council of Europe, so right across the whole of Europe. Now then along came a Labour government in 1997, which decided it should legislate this into law specifically. And they raised a consultation paper. Government never consulted until then. So nobody had any sort of principles on how to do it, but they tried to rush out this rather grubby consultation, which asked questions such as, should there be exceptions for us having contact with vulnerable people, or to work with children? So, they were gunning for, should there be exceptions to the rule for teachers and care workers, and Lord knows who else might fall into that kind of definition. And at that point, we had just set ourselves up online And we were sort of trying to work out what to do with this new tool called the internet, whether it was with email or through our little website. And so we got the consultation paper. I remember driving around to Stephen's College in Manchester. He was on the pavement. He handed me a copy of the consultation paper because the Department for Education and Employment didn't have email in those days, so they couldn't send it to us. So he gave me a copy which was still warm because it had just come off the photocopier. I beetled home and stuck it through an OCR reader and turned it into text and proofread it so we could put it up on our website and send it out as email to our followers with instructions to say, okay, they're going to have this consultation, we will be consulted. So in the course of about 10 days, the government didn't know what hit it, because I think it was expecting to just quietly put this out. One or two people might respond, and then they would quietly enact the law. But what they got was over 300 responses, which absolutely floored them, and showed that to us that this new internet thingy, if we could get enough people to join us on it, could be a really powerful tool. Because our problem as activists, because I think by this point we could call ourselves activists, was that trans people appeared to be very rare, very isolated, very poor mostly, and scattered all over the country. So how do you, there was no Zoom, obviously, there was no Facebook, no Twitter, none of that stuff. The only way we could get to people was either by sending out a big mailing. And by that point, we had about 1,000 people on various mailing lists. And again, sending first class post to 1,000 people those days cost about £250, and took a lot of effort of folding and stuffing and licking and stamping and posting. So we didn't do it too often. But with this stuff, with email and having list servers and web pages, we could communicate with people in the space of an evening. We'd taken a consultation paper we'd never seen before. We had it in the hands of over 200 people by the end of that evening, with instructions on what to do. So this was powerful stuff. I don't think anybody else was actually using online in that way for activism at that time. So there was nobody to copy. There were no instructions. We just had to make it up as we went along. And so case after case came along, and I have to write these down so I can remind myself. So I've talked about this case involving P, which became known as P versus S and Cornwall County Council, and that gave us our employment rights. They did eventually turn up as regulations that modified the Sex Discrimination Act in 1999. We weren't 100% happy with them, but at least we could agree on what there was, and that was immensely useful. There was also a case of X, Y, and Z versus the UK in 1996, which concerned the right of a trans man to be recorded as the father of a child conceived by donor insemination. And if that sounds at all familiar, then it should be, because we've had, recently in the press, cases just like that. Now, in that particular case, we lost, but the important thing that we gained was a confirmation from the European Court that trans people can have family life, they can have families, and we have rights with those families. Then there was another case that went to the European Court on the same basis as Mark Rees and Caroline Cossey. That was in 1997. In fact, there were two trans women. One was Christina Sheffield and the other was Rachel Horsham. Almost exactly the same arguments. But the interesting thing is that 7 years on, Christina and Rachel nearly won. They would have won if one judge had voted the other way. So it was getting close, and it was becoming clear that the European Court of Human Rights was getting a bit pissed off with Britain, and they were leaving very big hints, because Britain kept saying to the court, yeah, look, it's very complicated, we need to work on it, there were finely balanced issues, but we're keeping it under review and we're going to think about how to do it. And it was clear that, by this point, there had been 4 trans people from Britain going to the European Court of Human Rights with exactly the same grievance and not getting anywhere. There was also another important case in 1998, which was called AD&G versus North West Lancs Health Authority. And that was a case which went on to provide us with the right to have a referral to an NHS clinic to treat gender identity. And there were other cases, but the important one was in 2002, when yet another pair of trans people went to the European Court of Human Rights, Christina Goodwin and somebody just called I. And yes, I think I'm about to overrun my time. Sorry, everybody, but this is a good moment anyway. So I think you know the answer to this, that by this point, the court was so totally pissed off with Britain that it unanimously voted in favour of those 2 women, and it necessitated that Britain should have a law to legally recognise trans people, and that's how we ended up with the Gender Recognition Act. So it's been a long story. Alex Carlile had said it would take us 10 years. He said that in 1992, and Goodwin and I was in 2002. So he was pretty well bang on the nail. And obviously the Gender Recognition Act was passed in 2004. So this was never an easy run. Nobody ever gave us anything. We had to fight government for it. And it seems that we're back in that position of having to fight again. But hopefully, through those stories, I've painted you a picture of what it was like to first create activism for trans people in Britain, and then use this novel idea of taking our government or service providers to court and winning on the facts, and then forcing things to be changed as a result of that. So I think there's still a lot of mileage in that, it seems, and that's why I'm really delighted that the Good Law Project has been raising money to support taking legal actions again on behalf of trans people, following the awful case of Bell versus the Tavistock Clinic. Anyway, I rattled on. I'm really sorry if I've overrun. I'll hand back to you.